Good morning, everyone. Welcome to the Workers' Mic, powered by the Midwest Coalition of Labor, right here on 720 WGN. My name is Ken Edwards with the Midwest Coalition of Labor. Sitting to my left is Ed Maher with the International Union of Operating Engineers. Good morning, Ed.
Good morning, Ken.
How's it going?
It's going well. Better than if we were in New York this week.
Oh my gosh! Imagine that.
With the orange skies.
My mom is in New York, and
Yeah.
she sent pictures of it, and it literally looks like somebody put an orange filter on the camera. It's legitimately the sky is orange.
The pictures don't even look real.
It's crazy.
It's the first time. I couldn't tell you the last time I was mad at Canada. But come on, Canada. Your whole country is a forest.
Somebody said it's actually not a forest fire, but it's actually the gates of hell opening up for Pat Robertson.
Well then.
Ooh.
Hey-o.
Shot at Pat Robinson, who recently died.
Okay.
I don't know what he was. He was some sort of evangelical. So here, let's quickly,
Yes.
because
You had some good news.
Yeah, we got a lot to get to this show. I want to just start with two pieces of sort of like a little mini success stories, and that is I got a call a couple weeks ago from a retired teacher from South Suburbs. And she said, and they're not part of the MCL, but she said, hey, I've been listening to your show, and I've been hearing you guys talk about the building trades. Mm-hmm. I have two grandsons that are in high school. One's getting ready to graduate. They're certainly interested in this. Like, can you help?
Yeah.
And I put her in touch with Marcus Jordan.
Who was on the show a couple of weeks ago.
Yeah, from he's our diversity coordinator from
the Operating Engineers.
Yeah, and he immediately talked to these kids, and I think they're going to have summer jobs through that Hire 360 program, which I think is an arm of
Chicago Federation of Labor runs. That's great.
And get them some experience in the building trades. And then hopefully from there they can, literally have an entree into the building trades. So it was really, really nice. She was really, really appreciative. Mm-hmm. And, so it's working. And then I got another one from the carpenters from Phil Davidson, who sits in often here. And he got an email from a spouse of a Polish construction worker that was 45 years old, doesn't have a great grasp of the English language, but says was a wonderful carpenter. And what they did was they put him in touch with a business agent that speaks Polish.
Right.
And I think they got him into the trade, helping him along, with his English. Mm-hmm. And that was also as a result of listening to the show on WGN. So
the Workers' Mic is changing lives, folks.
One at a time. So
and that's the goal. I mean, we want to help people.
It really is the goal. So if you're interested, if you have a kid, if your kid isn't, doesn't know what he wants to do, if you're interested, just pick up the phone. You can call the Midwest Coalition of Labor, 800-433-2099. You can find us on WGN. You can find us Workers' Mic on social media, right?
Coalitionoflabor.org.
Yeah, we got the YouTube channel. I mean, the world's your oyster. So those are two just quick sort of feel-good things to start off this Sunday morning.
We've got a guest coming in, Rob Etin. He's an employer-side attorney. He's going to talk a little bit more about the Glacier case that we touched on briefly last week.
Yeah, and let me say we had to have an employer-side attorney because we wanted to have a union-side attorney first.
And we will,
but he wasn't available. So
next week,
Rob is great. So
let's take a quick break.
Looking forward to having him,
and we'll get Rob on the line.
We'll be right back with the Workers' Mic right here on 720 WGN. Welcome back, everyone, to the Workers' Mic right here on 720 WGN. I'm Ken. Sitting next to me is Ed. And as we talked about at the start of the show, we're really happy today to have with us on the telephone Rob Etin. Welcome, Rob.
Hi, Ken. Hi, Ed.
Nice to talk to you, Rob. Thanks for coming on.
Yeah. Thanks for coming on, especially at such short notice on a Sunday morning. Hey. Full disclosure for everybody, Rob Entin used to work at my former employer, Local 150, and Ed's current employer, Local 150, and Rob was an in-house attorney for how many years, Rob?
Was at Local 150 for about 9 years and then represented them for about 2.5 years. Before that, at a law firm in the city. So
about half your career has been spent on the union side. And you then went and you switched sides and to go work with your father, if I remember correctly. Am I right about that?
Yeah, Yeah, no, I went to go work at a law firm that my father was also partners at. He's not a labor and employment attorney, but it was a good opportunity to kind of work with Dad as he was kind of easing out of his career. So
most times I would absolutely hate people that switch sides, but in your case, I liked you and you had a pretty good built-in reason, like I'm going to work with my dad. So like you get some dispensation, and also you're a member of the tribe.
So where do you work?
Yeah, so where do you work?
And what do you do?
Sure. So I am currently at Ford Harrison. I'm a partner there.
Harrison Ford, the actor?
Not Harrison Ford.
You must get that a lot, though.
Ford Harrison.
Do you get
Ford
that a lot?
Harrison.
Yeah, you're about like the seventh person today, I think, to go ahead and try that.
You know what?
Who was around first, you guys or Harrison Ford?
I think it's a tie.
Ugh,
but
that's
it's
confusing.
Close.
That's tricky.
So, Ford Harrison, labor and employment boutique here in Chicago. We got national offices. I think about 20 or 25 offices throughout the country.
Wow.
So that's where I'm at, and have only been there for about 2 months, but enjoying my time. Really smart attorneys. Really good people.
But you were an attorney with your dad's firm for quite some time, right? So you've been about 12 years on each side, give or take?
Correct.
Okay.
Yeah, it's I was at Pulsanelli for about 12, so it's about a nice even mix. So I've seen a lot and got a lot of different perspectives, which has been it's kind of neat.
Yeah, so and let's get into it. One of the reasons that this is just really serendipitous that I called you, and I haven't talked to you in a while, but we're Facebook friends, and I always considered you, to be blunt with you, a really good guy, sharp guy, and I enjoyed working with you. Is that come across my email, and there is an article, and it says High Court labor ruling is a ripple, not a sea change, and that, of course, goes to the case that Ed and Phil were talking about last week, the Glacier case, right?
Yeah, Glacier Northwest, it was an 8-1 decision. Mm-hmm. I think that it's not, at least, from my perspective, from the management side, I think that most of us thought that that's how the court would go. I think that if there's a surprise, though, it's that 2 of the liberal justices actually joined in the majority.
That was certainly a surprise. For everybody that's tuning in for the first time about this topic. Number one, we're talking to Rob Etin, management side attorney with Ford Harrison, who has a unique perspective, I think, on this case. Number two, we're talking about a case that the United States Supreme Court decided.
It was late last week, and the facts of the case, to just be kind of brief, were there was a Teamsters strike in the state of Washington where a concrete company, Glacier Northwest, their drivers went on strike as a concrete pour was being prepared. The drivers took the trucks back. Most of them left the trucks spinning, but walked off the job. The company wanted to sue the union for damages, the spoiled concrete. And typically the National Labor Relations Act preempts any kind of, private financial damages at the state level in state court. They say it's the jurisdiction of the National Labor Relations Board. So the Supreme Court took this up and ruled against ruled against the Teamsters and said that in this case, the assertions that the court made were I found them to be kind of questionable. They took a lot of things. I think they just assumed a lot of things, maybe falsely, but in the end, they did say that in cases where that there were cases where the federal law did not provide this right. It was not as broad as it had often been expected to be. So. They just sort of put a hole in this, put it back to state court.
They didn't award damages to Glacier. What they did was they sent it back to state court.
Right.
That doesn't mean that Teamsters is going to get hit for anything, quite frankly, right? The state court might say, no, we don't find that whatever the Supreme Court held in their new standard of, you should have reasonably known that there would be damage to property. We don't find that.
Yeah.
Rob, you tell me, because what's funny about this article is you start off by saying in the sword fight between King Arthur and the Black Knight in the film Monty Python and the Holy Grail, the Black Knight tries to minimize the damage that King Arthur is inflicting, right? When he gets his arm chopped off, it's like
but a scratch. Yeah.
And I just thought that was hilarious. And that was funny. So you could tell us why you say it's a ripple and not a sea change, Rob.
Well, I think there are a lot of ways that the court could have gone in this case and just decided not to. Look, the first thing I want to say is I don't think that I don't want to minimize kind of how this should be perceived on the management side, right? This is, I guess you would call it a victory. It's a decision from the Supreme Court of the United States that allows employers to go ahead and file state court lawsuits seeking damages under a conversion, trespass to chattel, which is fancy lawyer terms for basically destruction of property.
Right.
So, I think that to the extent that, the last couple of years, there have not been many favorable decisions that have been coming on behalf of employers, this certainly is something to celebrate. It's probably an overstatement, but it's something that
when you say not, let me interrupt. When you say not favorable to employers, you mean coming out of the National Labor Relations Board. You don't mean coming out of the Supreme Court.
Right? Yeah. Right. No. Supreme Court is what the Supreme Court is at this point. So,
which is an arm of the Republican Party.
That's one way to say it, Ken.
Just ask Clarence. Ask Clarence's wife, Ginny.
Conservative justices.
Yes.
No, so it's. I want to be clear, just because it's a good decision for employers. The thing that I think where there should be, or there may be some disappointment from the employer side, is that I think that they had an opportunity to go much farther.
Well, they certainly hinted at it, and kind of like in what I see as the case baiting is what I call it.
Yeah. So I think
perfect way to set it up.
Thank you.
As far as like what Justice Thomas and Justice Alito and their concurrences kind of said. Look, we're not asked to revisit Garmin Preemption, which is kind of the Supreme Court case that says that if there is a conflict between state law and NLRB law, there's an arguable conflict, then we defer to the exclusive competence of the labor board in those cases, which is a lot different from when there are conflicts between federal and state law, which federal law will always trump. So, I think there is, you use the word case baiting. I think that Justice Thomas and to a lesser extent Alito may be soliciting that if an employer wanted to go ahead and challenge Garmin, that they at least would be open to revisiting that particular standard. But when I say that, I think that this case it's not as big of a deal as some of the headlines that you may be reading that says that, employers can now sue in state court for damages.
Right.
There are several reasons why. Number one, employers always had that right.
Exactly.
Of course they did. If a union or somebody intentionally damaged their equipment, whether strike or no strike, of course they can sue.
Strike or no strike,
yeah, of course,
exactly.
Absolutely.
So this is not. I mean, again, I think you have to when you read the decision doesn't necessarily open up all these new avenues as it's kind of been publicized, and I think as some management, attorneys or the management bar had been hoping for the court to do. I mean, look no further than what the court actually said about kind of the spoliation of product, right? Because that's what we're really talking about here. Right?
Yeah, hardened concrete.
We're talking about concrete, right? The hardening of concrete, and when it's left in a drum for so much time that's going to harden as well. And then you're talking about damage to these ready-mix trucks, which you're talking about tens of thousands of dollars, right?
Right.
The court could, the union went ahead and made an argument. I think it was like one of their secondary arguments they made that said, look, there are all these board cases, and whether it was milk or cheese or poultry, where the labor board had decided that, even if that is kind of a byproduct of the work stoppage, that just because property has been damaged or destroyed or is unusable, that's not going to render a work stoppage unlawful. And I could have seen, I'm actually a little surprised. You would think that someone like a Justice Barrett, and maybe, again, if I put on my thinking hat, maybe it's because they wanted some buy-in from some of the more liberal justices as well. They could have taken that step and said, look, if you're talking about damage to perishable goods, it's unlawful. It's an unlawful work stoppage. If you're talking about destruction of property, it's an unlawful work stoppage. But in this particular case, they stopped short, and that's why I think that the decision is actually a very narrow one.
Right.
That likely is going to put a halt to the practice of targeting concrete pours just because of that particular damage. But then taking it another step, I'm not seeing it from the language of the decision.
I mean, I think,
considering that this is a conservative majority, it's a little surprising that they actually didn't even consider, other than the concurrences, to go ahead and whether it was attacking Garmin or having a much more broader general kind of rule when it comes to employer property damage during these work stoppages.
Well, I think what they did, certainly they made it, they put out word to unions across the country that if you engage in a strike that causes any sort of potential economic loss, which, let's be honest, that's what happens in strikes, a lot of the time, you could be tied up in court, you could be tied up in lawsuits. But I mean, the Janus decision and other decisions that have hurt workers have often been the result of these types of decisions where they say, well, we didn't challenge this law or this precedent, but if somebody brings a challenge, we would happily consider it. So what Clarence Thomas did in his concurrence was once again just kind of hand a roadmap over to do something that will ultimately come to the Supreme Court. I think anybody who thinks otherwise, I would kind of question that, but it's something that it's queuing up the next decision that's actually going to be a legitimate harm to workers.
Of course it is, and it's been nothing but that. And Janus was actually a precursor to the overturning of Roe v. Wade.
Right.
They used the Janus decision. There's no more what we call stare decisis, which is reliance on past Supreme Court cases that you have to have a really darn good reason to overturn them. Now they're just getting overturned willy nilly.
Right.
But let's go back to this for a second, Rob. Is it like Ed had a point the other day that we were chatting about this? Like, what happens if you tell the employer preemptively or put it in your contract that we might strike at any moment? Like, there's no strike clause.
Like an unfair labor practice charge has been filed. We may strike at any moment as a result of this.
And you're hereby put on notice that you need to have contingencies in place in case we go on strike, and then shift the burden to the employer. What do you think about that, Rob?
Well, it's interesting that you bring that up, because I think that Justice Barrett actually put the distinction, and one of the reasons why she found for the employer, or the majority found for the employer in this case, is this idea of lack of notice.
Right.
I don't read the decision as being a decision where unions now have to provide a certain amount of notice. Look, I mean, obviously, if you're in the healthcare industry, there's a 10-day notice that's required.
If you're here in Illinois, the public sector, right? There's a notice requirement.
There are notice requirements everywhere, but I don't think that it's not necessarily. I think that Justice Barrett would tell you it's not the lack of notice which the court found issue with. It was that she concluded that the timing was done with the intention of having that property destroyed. And that's why this isn't a case that is preempted by Garmin.
Right.
Because the union should have known that they're foreseeable and imminent danger to the actual product. So,
which by the way, once again takes away, workers' leverage and rights to economically hurt an employer. Because God forbid, we should hurt an employer where they're knocking down our wages and cutting our benefits and taking away our rights, 6 ways to Sunday every day. But God forbid, we spoil some concrete and voila, you're getting sued. Let me ask you a question, Rob. We have to take a quick break right now, but would you stick around with us for our next minutes? Yeah, a couple more minutes for our next segment.
Only if you allow me an opportunity to rebut your last statement.
Rob, you've done enough talking so far in this interview. I think I just want you to be on the phone. I don't actually want to hear what you. Yeah.
Happy to stick on by.
You got to hear what this guy's got to say. Jesus Christ, I don't remember him talking. So
all right, let's take a break. We'll be back in a few minutes right here on 720 WGN.
Welcome back, everyone, to the Workers' Mic right here on 720 WGN. I'm Ken. Sitting here with me is Ed, and we are still lucky to have Rob Etin from Ford Harrison on the phone with us. Rob is a management attorney, as we talked about, and we want to just wrap up a couple more minutes talking about this Supreme Court case that we talked about in the segment right before, the Glacier case, which basically sent it back to the state court to say that the act of letting this concrete spoil might open up. I say it doesn't necessarily say it would open up the Teamsters to damage.
And this was a case that was reported in national media as just being a major hit on unions. And Rob's article was basically saying this is not as big a deal as it's being made out to be. Like, a lot of the things that are being stated in this case are things that already existed. So, let's not get carried away with this.
A flesh wound.
Yeah, a flesh wound. I mean, literally, it draws some fun parallels to Monty Python and the Holy Grail. It's a fun article to read.
It's a great article. Hopefully that it will get back from behind the paywall soon, which I tried to get around this morning and I couldn't, which is why I called you directly, Rob, and I appreciate that. I want to put a bow on this. What do you think? Let's just put on your future hat. What do you see in the future? What's the next case that stems from this decision?
Well, so 3 takeaways that I think is clear from the decision. First one is the practice of targeting concrete pours is going to lead to damages. I don't know how you read the case any different way.
Agreed.
So, that's number one, and that's the narrow reading that I kind of referred to in the article, which I believe is going to happen on a going forward basis. The second thing is that I think that more employers will file lawsuits in state court, and I think that they will be able to get past the motion to dismiss stage. Whereas historically, a union can go ahead and say, hey, preempted by Garmin. I think that the court would go ahead and say, yeah, that's the exclusive competence of the National Labor Relations Board.
End of that case. Now you're going to have companies trying to.
I think you're going to get into the discovery stage. More easily.
I think you make a really good point there, and it's a double-edged sword, Rob. Right, because you might have company A that's a multinational corporation that's got huge deep pockets that can fund that kind of litigation. But you also might have company B that has 3 employees and 2 trucks and doesn't want to take that chance or doesn't have the money to fund it. So, I think you're going to see a mixed bag. But go to your point number 3, which I think I know what it's going to be, but you go ahead and make it.
Well, I think point number 3 is that I think that Justice Thomas and Alito, in their concurrence, invited employers to go ahead and take aim at Garmin.
And when you say Garmin, explain Garmin.
When I say Garmin Preemption, sure. So Garmin Preemption, Garmin's a Supreme Court case from, I think, the late 50s. And what Garmin says is that if there is an arguable conflict between state law and NLRB law, that we're going to go ahead and defer to the National Labor Relations Board.
Sounds good.
Which is a stark difference between when there are conflicts between federal and state law, because in those cases, federal law always trumps.
Right.
So what has happened is that many times when employers have filed these state court lawsuits, whether it's for destruction of property, whether it's seeking some kind of injunctive action, unions would go ahead and file motions to dismiss based on Garmin Preemption, saying that you got to go to the labor board, and those cases were granted. That's what happened in Glacier Northwest, is where when the employer brought this case, it was dismissed and deferred to the labor board.
Right.
Justice Thomas, in his concurrence specifically, I think that he said that something along the lines of, although we weren't asked,
right?
It
said although we weren't asked, we should challenge this or consider this.
We would be, we do think that Garmin should be looked at a little bit more closely.
Was that? Did he say that? Did he say that when he was driving Ginny to the insurrection? Hey Ginny, what do you think about this? While we're riding down to the insurrection, I'm thinking about challenging Garmin.
Yeah.
Look, this is what I would say. I think that if you follow the Supreme Court, that type of invitation, whether it came from Justice Thomas or Justice Alito or Justice Gorsuch, I mean, that's not a surprising position, I think, for them to go ahead and take.
And it's funny. It's funny. So I just want to stop you there because I think we're almost out of time. But I'll say this: you're first of all, you're 100% right. Second of all, anytime right now, and probably for the past, I don't know, 10 or whatever, since there's been a conservative majority, anytime that the Supreme Court takes up a labor case, it is not going to go well for labor.
For sure.
And we have to, in labor, speaking on behalf of workers and unions, we have to understand that, be ready for it, be proactive, pass laws, which we're going to talk about in a second, and get our ducks in a row to make sure that we're not hurt by these kind of cases. I think you're right, Rob, that it was a ripple, not a sea change. I think the sea change is still coming, right? Yeah. I think that the tidal wave is still on its way. It's out to sea at the moment, but you're going to see it. Get it out to sea change. That's a Ken Edwards original.
Was that a joke?
I don't know. It was a play on words. It wasn't particularly
I don't even
funny.
know if that was a play on words.
Okay, whatever. I'm just trying.
You may be able to cut it for the interview. Let the production go ahead.
Leave that in. Leave it in.
No, don't leave me failing on a joke. Okay, no fails. But hey, listen, Rob, we got to go. I really, really appreciate your taking the time. We've been talking with Rob Etin. Rob, are you a partner?
I am a partner at Ford Harrison.
A partner at Ford Harrison, which is a nationwide law firm?
Yeah.
Representing
national
management.
National labor and boutique law firm, have offices all over, including here in Chicago.
Sounds good. We really appreciate you coming on the show. We're going to take a quick break, and we'll be right back with the Workers' Mic right here on 720 WGN.
All right, welcome back, everybody, to the Workers' Mic right here on 720 WGN. Ken, what'd you think? I mean, I thought Rob was a very insightful guest.
Yeah, he's really well spoken, and in my view, and it might not be the popular view, but I think there are really two different types of management attorneys. One are just straight up union busters that will do anything to get rid of the union, and then there are attorneys, which I believe Rob falls in the category, which are management attorneys who zealously represent their client, but will also tell their client, like, hey, you should settle. Because some attorneys will tell their client, fight, never stop fighting. And the only people that are making money are the attorneys.
Yeah.
And so I think Rob is pretty pragmatic, as you heard. And I also think he's pretty sharp. So I enjoyed that conversation. Next week, we're going to hear sort of a possible counterpoint from a union side labor attorney.
Great.
Yep.
Yeah, I think it's useful to go through and see both sides.
This is actually the first time in the Workers' Mic history that we've actually had somebody from management on, right?
Yeah.
So
we're equal opportunity these days.
Not really.
Well,
I mean, 1 out of 35 shows.
Yeah, don't get used to it, folks.
Yeah. Hey, listen, we got an agenda here.
Yeah, absolutely. But no, I thought he was great.
Yeah, and and one thing we didn't touch on, but I will just continue this conversation for a quick second. And here's the brilliance of labor right here in Illinois, and that is labor got a bill passed that amended the
Illinois Labor Dispute Act.
The Illinois Labor Dispute Act, which basically preempted the case that just came down and said you can't get monetary damages unless otherwise provided by law, i.e. somebody intentionally damaging property, et cetera, et cetera. But this is why the union movement in Chicago and what seems to be spreading around the rest of the Midwest, Wisconsin and Michigan and what they're doing, and Minnesota and Indiana, you're really seeing these unions start to prick up and pay attention and see what's going on and get ahead of the curve.
Yeah.
And so the workers' rights amendments and passing laws like this, and just getting out in front of it. So we knew that case was going against us, right? They went out and passed the bill, and we think the governor's going to sign it pretty quick, right?
Yeah, it's been sent to the governor. The governor's going to sign it in the next couple of days, and I would offer a lot of credit for that foresight to some of the really, really thoughtful and brilliant labor lobbyists that are working in Springfield, working in Chicago. We had a couple of them on last week, Mark Polis and Dave Sullivan.
Super cool.
And they talked about the state law that you're referring to, which hasn't been signed into law yet, but it's House Bill 2907, and it will protect Illinois workers and Illinois unions from the fallout of the decision that we've just been talking about.
Let me ask you a question, though. I mean, if you get a chance to read this case,
Glacier Northwest.
It's called Glacier Northwest. Just Google it. And feel free to read the majority decision if you feel like it. But there was one dissent, and it's the newest Supreme Court justice. I can't
Ketanji Brown.
Is that what her name is? And she wrote this really well-reasoned, dissent. And a dissent is basically where you disagree with the majority opinion. Get it if you get a chance, read it, because if you lose the right to strike,
right,
what do you become?
Yeah.
I mean, literally, do you become an indentured servant? Do you not have Twitter can come in, walk in, and fire 75% of its staff. But if you were to walk out from Twitter and somehow cause them damage, et cetera, is Twitter going to sue you now personally? I mean, this is just a union case, right? What happens if 3 people decide to walk out of their Starbucks and they're not union? They just walk out of the Starbucks because, I'll give you an example, in New York, the air quality was so bad that some people literally just walked off the job. They had to go home. They couldn't breathe.
I mean, they canceled a lot of Broadway performances.
They canceled schools.
They canceled sporting events because employers weren't going to ask their employees to get on a subway, get in a cab, walk down the sidewalk, and come to work because the EPA classified the air quality as extremely hazardous. A lot did.
Yeah, some employers are like, what smoke?
Yeah, you can't come to work. I don't see everything's fine.
Wear a mask.
Today's just an orange day.
The skies are their normal orange color.
Yeah, it's orange. It's that time a lot this time of day. What time is it? Oh, time to get your butt to work.
Exactly. But what I'm saying is, like, some people just walked off the job.
Right.
And I saw some guy holding a sign that says, "This is protected concerted activity," and he's right.
Yeah.
Except now what? Like, what is the employer going to sue you? And then what does that do? It puts a chilling effect on people's ability to strike and people's ability to exercise their action.
100%.
And go like, oh my God, am I going to get sued? Like, maybe I should stay here and breathe in toxic fumes.
I mean, as Rob suggested, one of the effects of this is it will make unions say, like, I don't know, maybe we shouldn't go on strike because we're going to get tied up in litigation. And even if we don't lose the litigation, it's going to cost a lot of money to pay attorneys and all this kind of stuff. So the signal that it sends is, once again, the Supreme Court is not in it for working people in the United States.
Yeah, which is a shame. It's a mistake. They were supposed to be nonpartisan. I have lost pretty much full
I mean, there's very little faith in the impartial nature of the Supreme Court.
Which is, and once again, I don't want to give a problem without an answer. How about term limits?
Yeah.
Pack the court, term limits, whatever you got to do, because come on.
It's a joke right now.
It's an absolute joke when they're case baiting and going, hey, if somebody brought this case, they might as well have already ruled. As a matter of fact, the decision is already pretty much written, just like they wrote Roe v. Wade and leaked it, or the anti-Roe v. Wade, whatever it is. So,
and the roadmap is being given out by Justice Clarence Thomas, who is being given free, $100,000 vacations from billionaire benefactors.
He didn't file his financial report yet.
The guy's got severe ethical problems, like that would put any other public official out of office.
Or at least shame them, and this guy's got no shame.
None.
Taking vacations from Harlan Crow, who is a billionaire benefactor, who sits on a board of an anti-worker, very, very conservative, anti-union think tank.
Justice Thomas's wife, Ginny, former stormer of the Capitol, I believe.
Actually, I think they rode together. I don't know why I keep thinking this. Like,
they only have one car. They carpooled.
They carpooled.
I'll be over at work, honey. Just come over when you're finished.
Clarence, can I get a ride to the Capitol? I don't know why I think that's so funny. Like, Ginny, I don't know if today's a good day to go there. Clarence, just get in the car and drive me to the Capitol.
I told you.
I got to storm the Capitol.
Yeah.
Anyway, so let's change. Let's change to some fantastic news.
Yeah,
and that is the spreading of strippers. Unions.
Unions.
Spreading of strippers' unions.
Yes. So we reported a couple of weeks ago that there was an L.A. West Hollywood, adult entertainment club where the dancers had organized under the Actors Equity Union, and it was the first one in the country. That movement's now spreading to Portland, where the Magic Tavern, which I think employs like 30 dancers, they have filed to become union as well. So we had said when we reported on that first, nightclub that had unionized, that we expected there would be more, and we're already seeing it. So
I think it's fantastic, and I think kudos to these folks recognizing that any job has dignity, like you've always said, including being
dignity
a
in all
stripper.
work. Dancer.
Sorry, you can't say stripper?
Dancer.
I'm literally looking at the headline. It says strippers.
It says dancers.
It does.
They
this
dance.
Says 4 seconds. Anyway, whatever. More importantly, they act. Because if you're a stripper, you got to act like you like that fat guy that's giving you money. So you're probably the best actress or actor in the world, right?
I would think so. I mean, it's
you should be in SAG.
As I said before, what do you mean, Ken? That she didn't like me? I thought she really liked me.
I stayed there all night, and I thought that afterwards I'd give her a ride home.
Yeah, she liked me until I didn't have any more money. I was like, "Oh man, do you have an ATM?" And she just walked away.
Yeah, well, I have an ex-wife like that.
Congratulations to not Ken's ex-wife, but to the dancers at the Magic Tavern in Portland.
I'm joking about my ex-wife. Maybe we can cut that out. I don't want to get sued again.
Okay.
So speaking of actresses and actors, SAG-AFTRA, right?
The Screen Actors Guild and the Television Radio Actors.
Yep.
They're getting ready to go on strike. They took a vote.
And what was the percentage of the vote?
It was about 98% of their members voted to go on strike.
Fantastic.
Their contract is over at the end of June.
Yep.
And we've talked before quite a bit. We were on location at the Writers Guild strike in Chicago. And so the Screen Actors Guild is getting ready to join them. And so you'll have writers, you'll have actors. It's very, very likely that nothing is going to change the fact that they're going on strike. I don't think they're going to reach any resolution. I don't even know if there have been any negotiations between the writers and the studios in their strike, but this is about to get a little bit bigger.
The writers have not been back to the table.
Right.
And I think now, and I said this last time, I think SAG, who has a much, much bigger soapbox, can get out there and save the day. I really do. I actually have faith in them, especially having now met the folks from the SAG-AFTRA local here in Chicago.
Right.
Just really, really wonderful people. But they have an action coming up, do they not?
Yes, this coming Thursday, June 15th.
June 15th?
Yes, June 15th out in Daley Plaza.
Which is where?
Downtown Chicago, over by the Picasso.
Right where the Picasso is.
Yeah, it's across the street from the CBS studio.
Okay.
And it's from noon to 3 o'clock. If you're in the city, head on over there. The last one was a lot of fun.
You think they're going to try and kick us off again and say it's private property?
Absolutely. And it'll work just as well for them as it did last time, which is to say not at all.
Yeah. So if you have the time, or if you're on lunch, or if you work downtown and you want to take a little time out of your day to go support these folks, I think, obviously it's a worthwhile endeavor. These are people that, work their hearts and souls to get to. Imagine being a young, struggling actor or writer right now.
Right.
I mean, it's got to be tough. Like, number one, you have a tough road to hoe to begin with. And number two, you're looking at, like, I thought I'd be rich if I was an actor.
Everybody, and that's what everybody thinks. These are actors. These are Hollywood writers.
Yeah.
They don't need our help. They're doing fine, and it couldn't be further from the truth. When people discover the reality that some of these writers are living in, it's terrible.
And some young actors as well. Like people think like, oh, I've been in a movie or I was in a commercial, whatever, and I'm a multimillionaire, and it's just not the case.
Right.
I think the people that are still living that dream are sports figures.
Yeah.
Right. I mean, their unions have negotiated guaranteed minimums for them, and while I'm talking about that, where are you, Major League Baseball players? Where are you, NFL players? Where are you, basketball players? Why have you not stood up and said something about this thing?
You know who came out in support of all this that I thought was great was Snoop Dogg. He had a tour coming up, and he said he was going to delay the tour because he was standing in solidarity. So Snoop Dogg, I mean, I love Snoop Dogg, always have. I think he's taken it too far into greatness where my mom now thinks he's cool, which makes me wonder if he's cool at all. But I think he's so cool that everybody likes him now.
It's hard not to like him, but but good for listen. If you have a soapbox and you're a famous, like Matt Damon's really good at it.
Yeah.
And Ben Affleck, I've heard, and Gillian Flynn, I'm not even sure if I'm saying her name right, has come out, and there's lots of pretty famous people that have come out in support of this thing. But I really do think that there's a dearth of support from the Major League Baseball Players Association, the NFLPA, like, come out and say something. Put out a show of solidarity. I don't know, put something on your field or something.
Yeah.
Anyway, because millions of people are watching you.
Right.
Or I don't know, Taylor Swift, the most popular person on the planet.
How about it?
Right?
Yeah, we saw that in Chicago. Everything. I mean, they said that they haven't had hotel rooms booked out. The hotel rooms in the city were like fully booked because of Taylor Swift.
Just remember Taylor and everybody else, and that is no money, no concert.
Right.
We have no money. We can't afford your tickets.
Yeah, absolutely.
So I know we've run our mouth again, but we got to wrap this thing up, don't we?
Yeah. We're out of time this week.
Bummer. Listen, we've enjoyed everything today. Thank you so much, Rob Etin, for coming on.
Yeah.
Thanks as always to Da Vinci Street. Thanks.
Check us out on YouTube.
Yep. Check us out on YouTube, on Spotify.
WGN
Radio, TikTok, which, by the way, our last TikTok got so many comments, the McDonald's thing.
Yeah.
I mean, just like vicious.
Get on there and check it out.
Yeah. Comment back, please. And thanks so much to WGN and the hard work of our studio folks as well. You've been listening to The Workers' Mic right here on 720 WGN. We'll see you next week.